Good afternoon, everybody. I was about to say good morning. Hope everybody's doing well and had I normally tell people to start with a cup of coffee. Hopefully everybody had a good lunch and is ready to learn for the next hour. We've got a pretty big class here. I think we had 80 people registered. So for that reason, I'm just going to ask all of you to stay on mute for me. If you do have questions, please put them in the chat. I have it up here. I'm looking at it and I'll do my best to answer questions as I go along. So my name is Patrick Fife. For those of you that don't know me, I'm LIBOR's general counsel. And before I just begin, I want to reiterate what I do at the beginning of every class is just to let you know where you should be going to get updated on new legal developments as they happen. This class that we give once a month, it changes every month because a lot of things happen during the course of the month. There's always new trends, new laws, new developments. And the best way for you to stay on top of those is to check out LIBOR's website, lirealtor.com, and also make sure that you're getting our weekly email that comes out every Thursday. A lot of the material that I'm going to cover today is in the legal tips that we put in every Thursday email. Also, a lot of great information about events on the website. Again, lirealtor.com. All the legal tips are there. And specifically to events, I just want to let everybody know that registration for our annual, this is going to be the 38th annual LIBOR Education Conference is now open. You can just take a picture of that QR code. The link is below. But I think the super duper, I don't know if it's called super duper, but whatever, super early bird registration is open. So there's a big discount if you register now. The list of all the speakers is there. I think it's going to be the best conference that we've had and probably the most well attended. So make sure that you sign up. I think we had about 700 attendees last year, but national speakers, local speakers, covering a host of kind of the top issues in the industry. So if you have a chance, go sign up and get your early discounted tickets. Again, also a lot of other good information on that website for you. I'm going to talk a little bit later about the Dispute Resolution Center and our Ombudsman program and how that can be a very valuable benefit for resolving disputes. But please take a look over there on the website. And the one other thing I want to mention is for about the last year and a half or so, LIBOR has had its own legal support center. You're probably all familiar with the NYSAR legal helpline. LIBOR started its own legal support center. It's available just for LIBOR members. It's staffed 9 to 5, Monday through Friday by an attorney, and we're able to answer general legal questions, provide kind of general guidance on real estate matters. Dial the number 631-661-4800, extension 335. And the Legal Support Center helps me too because I get to learn a lot about what you're asking, what's on your mind, what's troubling you, what are the things that are keeping all of you up at night from a legal perspective. So I get a summary, and very often I speak to the attorney who's behind the Legal Support Center, and we talk about some of the issues that come up. And what then I do is base some of the legal tips that I put together and also go over some of the, I'll call them either the more important or the more frequently asked questions that seem to be coming up every month. So this one came up a few times, and I've had people ask me this, and we've actually had some ethics complaints that have come in concerning this particular fact pattern. Listing agent is requiring a buyer to use a particular lender. And is that a valid thing to do? Well, it depends. Certainly, if the seller is directing that lender preference and they're applying it uniformly, that's okay. But it needs to be directed and initiated by the seller. So a seller may I don't know how many sellers would do this, but there could be some sellers that say, certainly financial strength of a buyer is an important factor. And maybe lender choice has something to do with that. But certainly that requirement, if a seller has that requirement, it has to be applied uniformly. Can't be applied just to some buyers and not others. But this is the important thing. The listing agent should never be the one imposing or suggesting lender requirements themselves. Um, it raises a host of issues under the license law, the Realtor Code of Ethics. You should be acting in the seller's best interest, not your own. So, to the extent that a listing agent is requiring buyers to use a particular lender because they feel that they have a relationship with that lender, they feel there's something in it for them, that is unethical, that is illegal. So it only should be in the instance where it is initiated and truly initiated by the seller. Second thing, if there is some kind of, let's say, not even just a lender requirement, but a general requirement concerning the types of offers that a seller will entertain, you as that listing agent should be presenting all offers received, even if they don't meet the seller's stated preference. Listing brokers should never be screening or withholding offers. You have an obligation to present all offers to the seller. So, here's the key distinction. The seller makes the choice among offers. The listing agent presents all of the offers. They're not the gatekeepers. They are not and should not be the ones setting requirements concerning the offer. They should come from the seller. All right. Another question that we got a couple times this year is about advertising and advertising as a buyer's agent. I've gotten this question from some members as well. Obviously, a lot of you're listing yourself as the listing agent, but can you advertise your role as a buyer's agent? You want to, take credit for your role. Yes, you can. The key is doing it in a transparent way. You need to be truthful. You need to be accurate and clear about who you represented. So, best practice is to state your role explicitly. I represented the buyer. I was the buyer's agent on this transaction. If you're advertising with phrases like just sold, that might imply listing side representation, and that's not something you should be doing. You do not want to have your ads suggesting that you were representing the seller or that it was your listing if you represented only the buyer. You could be subjecting yourself to discipline. You could be subjecting yourself to a code of ethics complaint. I've seen complaints in that nature that have been made and that have been successful, where a listing broker saying, "Hey, this other agent didn't represent my seller, and their advertisement makes it look like they are." You have an obligation to provide a true picture in your advertising, no exaggeration, representation. I also want to say be careful with MLS photos or photos of the property that you did not take. I've seen ethics complaints brought on this as well. Just because you're the buyer's agent and you represented the buyer through closing doesn't give you the right to use the MLS photo or any other listing photo. So you shouldn't be superimposing your smiling face over the first photo of the property that's on the MLS and putting it on your Instagram page. That's a copyright violation. That's a code of ethics violation. That's a licensing law violation. And it can and has triggered complaints by listing brokers. You should be taking your own photo, using your own photo, whatever it might be. You want to take a photo with your buyers? Great. Go ahead, promote the heck out of it, but don't use the listing broker or seller's photos. You can be getting yourself in trouble. And again, I've seen complaints come in on this, so don't think no one's ever going to call me on it. They may. All right. This question, how do I properly advertise myself as a licensed realtor? It's a bit of a trick question. Why? calling yourself a licensed realtor is not proper under New York law. There's really no such thing as a licensed realtor. Your membership in the National Association of Realtors through LIBOR is not a license. You have two things. You're a realtor, right? That's your membership in the National Association of Realtors, that you follow a strict code of ethics. But separately, you have a license. That license comes from the state. Realtor membership has nothing to do with the state. You need to be licensed to be a realtor, but they're two separate things. And the requirement in New York is not that you advertise yourself as a realtor, but you have to advertise yourself based on your license type. Um, you'd be stunned how many of our members confuse this and don't understand the difference. There is a difference, and the requirement in New York State is that you advertise yourself based on your license title. So, real estate salesperson, real estate broker, associate real estate broker. There's a checklist that was attached to the materials that were sent to you for this class. I strongly encourage you to take a look at that. That's the same checklist the Department of State will use if they ever receive a complaint against you, and they'll look at your advertising. Take a look every 6 months. Just review your advertising. Make sure it all falls in line with that checklist. That doesn't mean, and we certainly want you to advertise yourself as a realtor as well. So you can advertise yourself as both a realtor and a real estate salesperson, real estate broker. But there are rules for how you advertise yourself as a realtor. You need to use the mark properly. Again, it's personal. It's just identifying you, the person, as a realtor. You cannot combine it with geographic locations and say, I'm Long Island's best realtor, or Long Island's realtor, or Suffolk County's realtor. You can't do that. And some people say, well, that's not fair. Well, it is. The mark belongs to all of you. So why should one of you get the ability to use it for your own benefit and call yourself a particular area's realtor? The mark, again, realtor is membership in this organization, and that you hold yourself to a higher standard. That's all it is. It shouldn't be used for any other purpose. All right. I see a question that came up, and I'll kind of address it later. There's a question about phone calls. We'll get to that in a little bit. All right. Next question. This actually came in a few weeks ago. I hope the answer is somewhat obvious, but it came from a broker. Learned my agent stole funds. What do I do? Confirmed it. Agent admitted to it, but agent is now not responding to me. What do I do? Well, first thing I think, as a broker, you want to discipline that salesperson. In that instance, if you learn that your agent stole funds, my recommendation would be you want to terminate that person right away, end your association with them. Very important. Protects you, prevents this person from doing it again, but also shows that you're exercising supervision. But then report the theft to local law enforcement, your E&O carrier, your insurance carrier, and Department of State. Some people might say, oh, well, I don't want to get DOS involved. Well, in that kind of instance where you find that there's some kind of public trust violation by one of your agents and you don't report it, and a member of the public reports it first, it's not going to end well for you with Department of State. I think you need to presume in that instance that a report is going to be made, and you should report it first. And report to Department of State that, yes, I terminated that agent. I took action, and cooperate then with that investigation. Similarly, I think if you're on another transaction and you learn that another realtor has engaged in some kind of violation of the public trust, I would certainly speak with your broker, but I think in most instances like that, my recommendation would also be to report that agent on the other side to Department of State. Still getting a lot of questions about the FAIR Act in New York City. That's the Fairness in Apartment Rental Expenses. Went into effect just about a year ago. Question is, can a landlord's agent on a New York City rental split commission paid to the tenant's agent? So tenant paid the tenant's agent, and landlord says, I want tenant's agent you to share your commission with me as part of this transaction. The answer is no. Under the Fair Act, the listing broker cannot receive any portion of commission paid by the tenant, even if it's indirectly sharing it with the tenant's broker. Landlord's broker has to be paid by the party that hired them, meaning the landlord. Tenants can pay their broker, a tenant's broker, but that tenant's broker cannot share then with the landlord's broker. It'd effectively be a pass through. It's not allowed. If the landlord hires the broker, the landlord has to pay that broker. Simple, no loopholes, no end arounds. Last question, just to cover before I get into some new things. We do get a lot of questions about commercial listings and what forms are required, especially when it comes to state disclosure forms. Believe it or not, the fair housing and anti-discrimination disclosure form is required on commercial listings. Even though it is a housing form, it is required at first substantive contact for all real property. So that disclosure form would be required. The agency disclosure form, the state agency disclosure form, is not actually required on a commercial transaction. However, brokers still have to disclose their agency relationship. It just doesn't have to be through that specific form. You can use it. My recommendation in most instances, I would probably say to continue to use it, because then you can demonstrate that you did disclose your agency. But certainly it's not required that you use that particular form. All right. All right, next, I see a question here. Seller requiring buyers must have pre-approval prior to viewing the home. A seller can make, I guess that's a question that kind of relates back to that first question that I asked about a seller requiring a particular lender. Yeah, I mean, sellers can require pre-approval, but that again shouldn't be something that a listing agent comes up with on their own or imposes as their own requirement. These should be requirements that the seller is requiring and that the seller is requiring of all prospective purchasers, not only some. All right, next topic we're going to cover is an MLS rule change regarding offer presentation. This went into effect last month. You may have received, or you should have received, something from OneKey. There had been a process in the OneKey MLS rules that mandated an offer acknowledgement form. It was a specific form required under the MLS rules. There were specific time frames. It was rules 405 and 406. They documented how listing brokers documented offer presentation, also whether the cooperating broker could participate in the offer presentation process, and there were specific time periods that were required for parties to respond to an offer acknowledgement request. So that rule, or those rules, were actually removed from the MLS. Even though they were removed, though, your ethical obligations still remain the same. And the reason these rules were removed is they had been mandatory rules that NAR required of all MLSs. NAR said MLSs don't need to require these rules, and one reason why is the rules are kind of redundant of rules that already exist inside the Realtor Code of Ethics. So that's what I want to talk about. What has not changed? So even though the offer acknowledgement form and that process under the MLS rules no longer exists, we still have standard of practice 1.6 or 1-6, sorry, which says that listing brokers have to present all offers as quickly as possible. We also have standard of practice 1-7, which says you as the listing broker have to continue to present all offers up through closing unless the seller has waived that obligation in writing. And also, you have to respond to written requests for confirmation as soon as practical. So if a cooperating broker sends you a request for a confirmation that you, as the listing broker, submitted an offer, you need to respond to that request in writing as soon as practical. No longer a requirement under the MLS rules that had a specific time frame or that required the seller to sign the acknowledgement, but the listing broker has to respond, and the response has to be as soon as practical. Um, NYSAR has a form. Remember, I said the offer acknowledgement form no longer is required. NYSAR has a form, and OneKey's made this available for cooperating brokers to send to the listing broker to obtain their confirmation that an offer was presented. The form is specifically designed to meet the requirements of Standard of Practice 7. So if you get this form as the listing broker, you are going to review it and return it by checking one of two boxes. You're either going to say the offer was presented, or the second would be that the seller waived the obligation to have the offer presented. You are only going to click that second box, though, if you have a written signed seller waiver saying, I no longer wish to receive offers on this property. Again, this form's optional, but it certainly offers a way to request an offer confirmation that your offer has been presented. So what happens now if, let's say, you're the cooperating broker, you sent that form to the listing broker and you get crickets? You don't get anything back from the listing broker. Listing broker ghosts you, ignores you, gives you no information about whether they submitted the offer. Previously, you could make a complaint to the MLS. The MLS no longer hears or processes complaints regarding offer presentation. So what do? If you're having that issue, you should contact LIBOR's professional standards department. I'll even back up though. Before you do that, I would say if you're an agent, speak to your broker. Your broker can probably reach out to the listing broker and kind of set things straight. But if that's unsuccessful, certainly reach out to LIBOR's professional standards department. You can seek ombudsman assistance, which I'm going to talk about in a minute. Or if you're just getting nowhere and the listing broker just either won't provide the form or ghosts you, you can file an ethics complaint. So two QR codes here, and we'll make these slides available to everybody afterwards, but we did a legal tip that goes through this in more detail. There's also the affirmation request form, a QR code to that. The legal tip also has a link to the form as well. So certainly opportunity to learn more if you have any questions about this. So really quickly, I mentioned LIBOR's ombudsman program, and this is something I've covered in the past, but I just want to go over it really quick. Reason being, we just did a program earlier this month, a fair housing program, and I asked about 100 or so of you that were in the room. I say you, members of LIBOR, they knew about the ombudsman program, and I think only 3 or 4 hands went up. It's towards the end of the day, so maybe people were getting a little bit tired. But it's just a great program that I want to let you know about. And reason being is that disputes, especially if you're a broker, right? Disputes concerning your business can get really expensive to handle. Some complex insurance claims, if you have to file a claim with your E&O carrier, it can cost you up to 6 figures, even if a case settles or is dismissed. Insurance costs, like everything else, are only going up these days. Deductibles on policies are 25, 35, $50,000. So if there is a dispute, it can be really expensive. I think brokers also need to consider that if there is a dispute, what does that mean? You're preoccupied with it, right? You're spending your time, your productivity, You're communicating about it. There's stress, there's anxiety, there's potential damage to your reputation, all negatives. So disputes are bad. You want to stay away from them. So what do we have here at LIBOR to help you? We have a free service. It's called an ombudsman program. All you need to do is call up our professional standards department, say you're having a dispute, you'd like some assistance, and you'd like to have an ombudsman try to help. And an ombudsman is it's a fancy word and for basically a trained and experienced realtor who can help resolve conflicts before they become problems. They're an impartial party. They're not a judge. They're listening. They're communicating concerns back and forth to try to get the parties to a better place and a positive relationship. Um, it's really simple. Most cases that we get into the ombudsman, and I think this year so far we've settled about 80% of them. And we get, several a month, 10, 12, sometimes even more cases per month. And they'll settle about 80% of them. So it's someone who wants to file an ethics complaint, an arbitration, a lawsuit. It could be a member of the public. They've got a breakdown. It could be that offer acknowledgement process. Let's say you're trying to just get your buyer's offer into the hands of the seller, and you want to make sure it was submitted. You don't really want to file an ethics complaint because you want to try to get a deal done, but the listing broker is not getting back to you. Maybe that's a situation the ombudsman can give a call to that listing broker or listing agent and say, hey, you've got a cooperating broker here who just wants to know that their offer was submitted. That's a simple one. They can get more complex, but typically the ombudsman's it's done with phone calls, and it could be a matter of minutes, hours. Sometimes it's a few days. But again, it's a pretty quick process. It's entirely confidential. It's free. It doesn't cost anything. This person's not a judge. It's not meant to be this combative process. They're not trying to say who's right, who's wrong. They're just trying to get the parties to work out a resolution. And oftentimes it's just because, like human beings, we sometimes communicate on two different wavelengths and we don't hear each other. They're usually pretty good at getting the parties to understand each other and more often than not reach a solution that doesn't become an ethics complaint, a DOS complaint, an arbitration, or a lawsuit. So really good process. I don't really think there's any downside, right? If you start this process, you're not happy with it, you can walk away. If you feel that the resolution that the other side's offering is not enough, file a complaint. Go ahead, file a lawsuit. This doesn't prevent you from doing that. So I just encourage anybody who has issues and you're concerned, try LIBOR's Ombudsman program. Again, that QR code is there. Just call 631-661-4800. Extension 3 is our professional standards department, and they would be happy to help you. Okay. Next topic I want to cover, and this is one that I know a lot of you are reading about in different publications. It's being talked about everywhere. It's the coming soon listings, the preview listings, and what does that all mean? And I'm gonna try to unpackage it in one way here, and talk about it in the context of our MLS here at OneKey. And I think the reason there's been so much discussion about this nationally is, believe it or not, a lot of MLSs don't offer coming soon listings. So that's why you're hearing it so much at a national level. But a coming soon listing it's a temporary status, right? It's used by sellers before full market exposure. And I say it's often misunderstood and misused because many MLSs, I'm not the one who came up with these stats. I'm relying on things that I've read, but I've read that approximately 20% of MLSs do not offer coming soon listings. So that's kind of fueling some of the discussion nationally. The other thing is in the markets that do, about 50% of those MLSs, they don't allow coming soons to go out on IDX, or they don't show them publicly, which our MLS does. So I think kind of the lack of choice that everyone, you read about in some of these publications that sellers have. It's more so in those regions where they don't have coming soons or where coming soons are not exposed to the market. So that's not the case here. So I do want to talk a little bit about what One Key's coming soon rules are and also what your obligations are under New York law when it comes to coming soons. Because improper use of that status can result in a licensing complaint. Um, so New York does not have any specific law that governs the use of coming soon. If you look up in the licensing law or the regulations, you're not going to find anything that talks specifically about coming soon. But we mentioned before, New York advertising, everything has to be truthful, right? And you're not allowed to have misleading advertising. So if you advertise a property inaccurately, even by implication, that can be a violation. So that applies to all marketing, including coming soon. So if you advertise something as coming soon, but then are actually showing it to certain people and not others, that's a problem, right? Because you're advertising this as it's not available, but if you're the right person, maybe it is. You can't do that. If it's coming soon, you have a fiduciary duty, to obviously act in the seller's best interest. And these include marketing decisions that are benefiting the seller, and in the seller's best interest. So you need to use coming soon to operate in the seller's best interest. It should not be used to generate buyer leads, or to double end transactions before the property goes on the market. Using a coming soon for that purpose is being disloyal to your seller. So, it's not something that should be used to benefit you. It should be used to benefit the seller when there's a reason, a legitimate seller directed reason to delay active marketing. So, if the seller has repairs that need to be made to the property. They want to stage it. They want to clean it up, right? It's not yet ready for showings. They want a predefined, defined pre-marketing period, right? To kind of test the market, to maybe get a sense of just gain feedback on the property before it actually goes onto the market as an active listing. Fine, that's what coming soon should be used for. But it should be the seller's informed understanding as to why. It shouldn't be up to the listing broker kind of driving that strategy. The delay should be limited in duration, and it should be to serve the seller's best interest, not the listing broker's best interest. Sellers should know that the property's not really it's not put on the market. And they should understand that delayed exposure is going to limit buyer access and it could affect pricing and bids. That, by putting it out here, we're not going to be soliciting offers just yet. You need to get informed consent from the seller under One Key's rules, and you should under New York. And basically, sellers should understand the potential downsides of coming soon before choosing the status, not after. So, we kind of went through these already, but you shouldn't be allowing select showings of a coming soon. It shouldn't be a lead generator for the broker. Certainly shouldn't be putting coming soons that are already under contract just to try to get, again, leads. If no showings, if any showings are occurring, even one showing, then that property is not a coming soon. And if you're advertising it as such, that could be a misleading listing, and a misleading advertising. One Key has rules regarding coming soon. It permits the use of them, but it has to be a short temporary period to allow the property to be prepared for showings, after which it must become fully active. Listings in One Key can be coming soon for no more than 14 days from the listing date. Once you've passed that, you can't extend or reinstate. It becomes active, and you do have to get the seller's written authorization. And again, I just want to preface this what I said before. A lot of other MLSs across the country don't have these flexible rules. It's to your benefit that One Key has allowed and does allow this, and does offer the seller the flexibility um, of uh, of of a coming soon listing, and that coming soon listing does get advertised out as well. So key restrictions for coming soon listings: you cannot be showing the property. It has to convert to active status on the on market date, and there is only limited advertising that is allowed. The listing does appear in the MLS, so it will show up publicly in the MLS as a coming soon. It'll show up in IDX feeds. It'll show up on VAL websites, MLS powered mobile apps. So we do get broad exposure, unlike some other MLSs. It can be displayed on the broker's website, provided it's marketed as coming soon. It can be emailed to clients, agents. Again, it has to be marketed as coming soon with no showings, but you can market it. It can be allowed on social media, flyers, as long as it is, again, marketed as a coming soon listing. And yard signs, same thing, permitted if they indicate it's coming soon. So it's a pretty broad approach for coming soon listings that the rest of the country, or the majority of the rest of the country, doesn't have in their MLS rules. Um, just reminder, coming soon. It's not a branding. It's not a lead generation strategy. It should be a seller-driven status. It should be used carefully. You always want to document it appropriately, get that seller's consent, and make sure they're aware of what it means and how it's serving their interests, and make sure that you are in compliance with the law, ethics, and MLS rules, because violating the rules can lead to serious penalties and potentially complaints. Um, all right. I now want to touch really quickly. I'm going to just go back. I see a question in there. If the seller is ready to start showing before the on market date, is that allowed? Well, I think in that instance, you would convert the listing to active at that point. I do believe that you can change the listing from coming soon to active sooner, but you can't start showing the listing before the active date. All right. I'm going to talk a little bit about a recent class action litigation settlement. And this is the NAR buyer side class action settlement. You may have heard about this or read about this in some industry publications. Um, Remember, going back in 2024, NAR settled the seller side class action litigations. Well, there was class action litigations brought about by buyers who also claim that the cooperative compensation rules that previously required you to put compensation on the MLS damaged home buyers. And they filed class action litigations all across the country, just like the sellers did. Well, the sellers' cases settled after there was a trial, and then there was a settlement. The buyer cases were still pending. NAR reached a settlement in one of those cases called Tacori. It was a nationwide class action litigation. There's a related case that you may have heard called Batten. That case is expected to be stayed, and this Tacori settlement is going to cover all of the buyer side claims. I could probably do a 2-hour class just on class action litigations and procedure and settlement. I don't think you want to hear about that, but believe me, by settling one case, you can effectively cover all of the class action lawsuits filed by similarly situated plaintiffs in other cases. And so that's what NAR has done. The settlement will need to get approved by the court. And the settlement is pretty broad. It covers basically, the bulk of the industry. It was a really proactive settlement. The idea was to avoid going to trial, avoid the potential for significant liability, and kind of put members, kind of put the past in the past, and allow members to move forward with certainty. There are no new practice changes required by the settlement. So unlike the Sitzer-Burnett case, which that was the seller side litigation, remember, it's kind of what we used to call just the NAR settlement. And I'll talk a little bit about what the impact of that settlement was. Hopefully, everybody's aware about that and following those rules. But beyond the practice changes that were implemented in 2024, there are no new practice changes that are going to come about. The release is really broad. It covers all of you as Realtor members, the state and local associations, Realtor and non-Realtor MLSs, and most brokerages as well. It's a more significant coverage than they were able to get in the seller class action litigation. Just a reminder, so I said there's no new practice changes, but you do need to continue to comply with all of the practice changes that went into effect in 2024. And looking at those practice changes and what they are, remember, no offers of compensation on the MLS. So the fields have all been removed. You shouldn't be putting offers or signaling offers in the agent remarks. None of that is allowed. Compensation has always been, but remains fully negotiable off the MLS. Buyer broker compensation has to be negotiated between the buyer and their broker, and I'll talk about that in a second. And you can't be steering based on compensation. So agents cooperate, buyer's agents shouldn't be selecting properties, filtering properties, or recommending properties just based on what the compensation that is being offered by the seller or the listing broker. Why? Because the rules now require and have required since 2024 that if you're representing a buyer, you need to have an agreement with them before touring a home. And that agreement is going to specify what you are being paid. The amount or rate of compensation to the buyer's agent is set by the buyer. Seller, of course, can pay that, but the buyer is the one that sets that rate. And it has to be objectively ascertainable, has to be, it can't be open-ended. State that the broker is prohibited, and any agreement has to say that you're not able to receive compensation from any source that exceeds the amount or rate agreed to with the buyer. So really, it just comes down to buyer sets the rate for their agent, seller sets the rate for their agent. I mean, that's the simplest way to look at it. And commissions are and have always been fully negotiable. Last point, just about the settlement, and this again, it pertains to both the seller and the buyer side litigations. Don't try any workarounds. You're only going to get yourself in trouble and potentially, void yourself from the protections of the settlement. So seller paid bonuses. If it exceeds what you've agreed to with your buyer, you can't accept it. Don't show a property with some, kind of general vague touring agreement and then try to reach an agreement with your buyer after you've shown the property. Don't include ranges of compensation. Don't say, I'll accept whatever the seller's willing to pay. All of those are problems. And they're not gonna give you the protection that you need under the settlement. Don't leave it blank. Don't leave compensation blank. Don't fill in the buyer agreement at closing or after you've already shown the property or after you learn what the seller is offering. Reach the agreement with the buyer and then just go and negotiate. Keep it simple. All right. All right. I've got about two more topics that I would like to try to cover in the last 10 minutes or so. I do want to give you just a very brief update. And I know I cover this in almost every course, which is just lawful source of income. And I mentioned we had a fair housing program earlier this month with some representatives from New York State Division of Human Rights, some other state organizations. Lawful source of income is still front and center in their undercover testing, and it's something that they take seriously. Remember that housing providers and you can ask about income and where it comes from and how much income people have, and you could ask for documentation of income. That's fine. You just have to accept all lawful sources of income equally and treat individuals equally based on where they get their income from. That's the distinction. So if your income comes from any of these sources, you should be treated just the same as someone who derives their income from a job. Um, you shouldn't be treating individuals differently based on the source of their income. That's it. So whether it comes from a voucher or Social Security, you treat that person the same. Whether it's Social Security or a job, you treat that person the same. We don't apply different rules for different sources of income. That doesn't mean if somebody has Social Security in the amount of $2,000 a month that we have to give them an apartment that the rent is $5,000 a month, right? Um, Same thing with a voucher. If the voucher doesn't cover the rent, doesn't mean that the landlord has to accept that person. But you need to apply the same rules based on that source of income. Um, so there was a recent, reason why I want to bring this up is there was a recent third department court ruling. Third department's an appellate court in New York State. And so this last month, March, there was a court that said the lawful source of income protections can't be used to require owners to participate in the federal Section 8 program. They said that it was unconstitutional because it forced owners to consent to warrantless inspections and provide access to records. So that right now, and I have the hand up there, it doesn't change anything, right? I know there was a couple of newspaper reports, and maybe it was on like a few of the local news channels, that this kind of changes Section 8, right? It has not. For the time being, things are still the same. Section 8 is still a lawfully protected class. And the reason why is the New York State Attorney General has appealed this decision. As soon as the state, in any case, appeals a decision, it stays the effect. It's not specific to this case. Anytime the state, the town, a local government appeals a court decision, the ruling is automatically stayed, meaning it has no effect until the appeal has been heard. So all lawful source of income protections in New York State and locally remain in full effect, including protections for Section 8. So if someone tells you otherwise, that is not the case. Until this appeal is heard, which could take a year, maybe more, by the time it's briefed and heard by the Court of Appeals, we won't know what the law, if there is a change to the law. But for now, all lawful source of income requirements and laws remain in effect. So you have to continue to follow all source of income laws. It, ruling doesn't pause enforcement. There are still many lawsuits that are an undercover testing that's going on. And I will tell you that undercover testing has continued to show violations, right? It's been a problem. And I note in Orange down there, Department of State has a zero tolerance policy, right? So, and they're continuing to abide by that. They feel there's been enough education and enough cases that have been brought before that everyone should know that this is the law now. So if you are found to have engaged in lawful source of income discrimination, Department of State will seek to have your license suspended or revoked. So, it's just something that the state is going to continue to look at. A lot of these cases involve just simple testing. It's phone calls to agents saying, "Hey, I'm somebody with a voucher and I'm interested in this apartment." And they're getting instances where then the next person calls up and says they have, a job and I'm interested in the apartment, and they're getting two totally different responses within 5 minutes. That can't continue to happen. So agents who are ghosting or not responding to people who say they have vouchers or saying apartments are not available, but then telling other people what jobs they are, they're going to be risking license suspension and revocation by Department of State. And these cases are continuing to happen. I mean, this is just an example from December of this last year. Um, and it's all the it's Division of Human Rights said a lot of it is just what I have here. It's people saying, I've got to find out, or putting added requirements on voucher holders, which is a term they call frosting. It's a new one that they're adding layers of frosting, additional things that voucher holders need to do in order to get the apartment. All of that is considered illegal. So what do you do? Well, it's really simple. This slide is like, this is it. This is the easiest way to prevent lawful source of income discrimination. Just have standard procedures. Anytime a prospective tenant calls, it doesn't matter if they have a voucher or not. You're going to treat them the same way. Just have a standard set of questions for all rental prospects who call. Um, where are you looking? What area? How many bedrooms are you looking for? What is your price range? That's it. There's no magic to this. You're never going to turn away a prospect because they receive financial assistance. It would be the same as turning away a prospect based on their religion, based on their race, based on their color, or their gender. You would never do that. So you're not going to do the same thing when it comes to their source of income. You're just going to treat somebody the same way and tell them about all the vacancies that meet their needs, regardless of their source of income. And if you find an owner who's not going to accept vouchers or subsidies and just says, I'm not going to work with those people, well, then you tell them, well, I don't work with you. Very simple. You just walk away from them, terminate the relationship. Do not put yourself at risk of losing your license. Um, Division of Human Rights. I keep saying Department of State. Went over this at our seminar. There's more information on this on our website on lirealtor.com, also on our Home for All of Us .org website. Just how to deal with credit check, credit score requirements, income requirements. Landlords can have them. It is not illegal for a landlord to have a credit score requirement or an income requirement. But if somebody has a voucher that covers 100% of the rent, they can't apply it to that individual because the person would never get it. You would effectively deny anybody that has a voucher. If the tenant is paying a portion of the rent, credit can be considered on a case-by-case basis. But you should realize that all these programs, they vet the individuals. They go through and determine what the individual can afford in terms of their portion of the rent. So to the extent that you are going to apply more, you could or put additional requirements, you're very likely in that case discriminating. Last point, and I've only got 2 minutes. I just want to remind you, cold calling is still prohibited in New York. It stinks. There's been a law in effect since 2020 or 2021 that says when there is a declared state of emergency in New York, no one is permitted to make cold calls. We are currently still under 2 states of emergency here in New York, and they will probably and very likely be extended. So until these states of emergency end and we're no longer under any states of emergency, all cold calling in New York is technically illegal. And I know it stinks and I know we get them all the time, but you do have a license. And Department of State does enforce this based on a complaint. They're obligated to. So unless you have an established business relationship with somebody, meaning that they've engaged in a purchase or transaction with you within the last 18 months, or they've made an inquiry or filled out an application with you in the last 3 months. So somebody who came to your open house, right? They inquired about a property and with you. That's not a cold call as long as they were within that last 3 months. But just randomly calling people or calling people who you haven't done business with in years, or that you got list of potential leads that didn't make an inquiry to you or fill out an application, that would be a cold calling, and it can get you in trouble if Department of State gets a complaint. And I don't think Department of State's out there testing people on this, But if they get complaints, they do have a duty to investigate them. And the fines can be up to $20,000. Department of State has tried to hold some licensees responsible for illegal cold calling. So it's a warning that is real, and it can get you in trouble if you are engaging in cold calling in violation. I will tell you, just up in Albany last week, I think I saw one or two people, at least on this call, who I saw up in Albany as well, or on the Zoom, who were up in Albany. We and NYSA are lobbying to get the law changed. It's not an easy push. As one legislator said to us, does anybody really like getting cold calls? I think the answer is generally no, they don't. But I think there is some sympathy to the fact that this law, as written, is kind of wacky, and should certainly get changed, and that it really should be a state of emergency that's tied to a true emergency that would tie up the phone lines, not something relating to overcrowding in jails or healthcare staffing shortages. So I encourage you, if you see a call to action, write your state senator, write your state assembly person, and tell them that this law needs to be changed, because I think there is a benefit, at least insofar as certain cases where there are certain groups that, somebody mentioned like the stressed homes. Yeah, calling people who you have no relationship with, that would be a cold call. But maybe those people need information. Maybe it would be helpful for them to learn of an opportunity to sell, so I just, if you really want to make cold calls, lobby, get involved. Don't assume someone else is doing it, and take the initiative. All right, I know I'm at the hour, so I'm going to end it there. Thank you, everybody,